May it please your lordship. I beg to mention for item number 19, 26, 27, and 29. In this, my lord, I have already filed an affidavit in reply, but these are not tagged with the records, my lord. May I send the requisition, my lord? Secondly, my lord, another matter that was not listed in the series, my lord, on 1st of February, I have already mentioned, but that was not listed today also, my lord.
Now we can't requisition a matter like that.
My lord,
We don't want to requisition the matter.
my lord.
It will be listed on some date. Whatever orders are passed, we'll cover the matter.
My lord.
Yes.
My prayer also sent my lord. 4, 6,
You-
7, 8, 10, my lord.
You give a requisition to pass a mention memo for listing the matters, we'll see.
Right.
You file a mention memo,
My lord.
My,
we'll permit the matters to be listed and then we'll see
my lord.
whether they're covered or not. Okay? Yes,
Counter affidavit file, my lord. Petrus not lit, my lord. Petrus requisition is sorry, my lord.
yes.
May I please your lordship? Lordship, regard to item number 41, lordship, I am praying for an adjournment on behalf of the respondent, your lordship. That is the university.
Hmm.
Lordship.
41 and 42,
41, your lordship.
only 41.
41, lordship. Actually, lordship, their department has asked us to seek some time to provide an
Have
instruction.
you informed the petitioner?
Lord, I appear on behalf of the petitioner, my lord. I have no objection with the prayer made by the my lord. I only paid the matter was taken up after a week, my lord. There is some urgency.
Lordship, on a hearing day, if it is fixed,
On a
lordship, then the
hearing day,
matter
but-
may be disposed of on the next day, your
We
lordship.
don't know.
As per lordship's convenience, lordship. Either on 22nd or
22nd, my lord.
27th, lordship, maybe.
Like
Or
27th,
27th, lordship.
that joint request matter be listed on 27th
My
February.
lord.
Much obliged, lordship.
No, with your lordship. Lordship, we have filed two interlocutory applications, lordship. That is, main case is fixed on 15th, lordship.
Huh?
Main case is fixed on 15th of February, lordship. That
15th.
15th. I will be allowed to.
You give the mention memos, these cases will be listed together. It's, 15th or 16th.
May
Yes.
please your lordship, I am praying for listing one WBC application for admission.
For admission, no, right. Let it be on 4th of February, 4th of March. 4th of March.
May it please your lordship, I beg to pray before listing his matter for admission, lordship.
4th of
Lordship,
March.
another similar matter has been pending before his honorable.
4th of March.
I know.
May I please the lordship, I pray for listing of WPC 295/2021.
Sorry.
WPC 295/2021. The matter was last listed on 24 Feb 2023. The matter may be listed on Friday, lordship, due to some urgency.
Not Friday. Come on. Let it be on 4th of March.
Lordship.
Yes.
Highly
What is the urgency in the matter? That a mention was made for listing.
Lordship, the urgency is that, lordship, the amount that has been calculated is a very critical amount, lordship. It was done by the help of the actual service. Lordship, that amount may not be adequate, lordship, if there is further delay. Only, lordship, one notification is required to be issued, lordship. Everything is finalized, lordship, now. Just to expedite the process, because, lordship, and now, lordship, the election, the model code of conduct may also be imposed. So the employees are apprehending, lordship.
Yes.
I'll take instructions, lordship. 3 weeks may be done.
3 weeks. No. They want only some notification.
Yes. Everything is filed, and the other departments have also given NOC, lordship. Only the amount.
Who is to give the notification?
Lordship.
Which department?
Lordship, lordship, in fact, lordship, the Department of School Education, Elementary, and lordship, the Managing Director of Assam State Textbook Corporation.
You represent textbook.
Yes, only textbook, lordship.
And who represents elementary?
And the person concerned is holding both the posts. He is in dual self. He is also the MD of STPCC and also the Secretary of the Education Department.
Heard learned counsel for the parties. This petition is filed by the Assam State Textbook Corporation Employees Union and some of the members. The grievance urged before this court is that there is a scheme a scheme has been proposed for, not a scheme, a trust. Trust has been formed.
Initially, scheme was formulated, and accordingly, Lordship, as per the income tax rules, Lordship, we have the trust was formed.
The scheme was formulated for pensionary benefits of the former employees. At present, there are 39 regular employees. This is only for the regular employees?
Only for the 39 regular employees, Lordship. Eligible
Only
regular
for the
employees.
39 regular employees. In terms of the scheme, the Assam State Textbook Publication, Production and Publication Corporation Limited Employees Pension Trust was formed, along with all necessary particulars for managing the trust, including obtaining the necessary clearance from the Income Tax Department. Stop. It is the submission of the learned counsel for the petitioner that in order to provide a suitable corpus, appropriate actuarial service provider services were called for, and a report to that effect has also been submitted. And the actuarial liabilities have been identified by in terms of the report. Stop. The Administrative Department of School Education Elementary issued NOC after obtaining NOC from all the other respective departments, including Public Enterprise Department, Finance, and Pension and Public Grievance Department. The amount of corpus to be transferred will be the amount to be transferred by the corporation without putting any additional financial burden on the state. Stop. However, the notification giving effect to the corpus fund, to the trust by transferring the corpus fund has not yet been issued. The apprehension expressed by the learned counsel appearing for the petitioner is that further delay may defer the effective setting up of the trust and its functioning, which has been given clearance by the respective departments. Stop. Learned counsel for the petitioner submits that the formal order from the parent department, namely the elementary education department. Is it elementary or school education?
Department of School Education,
Department
Elementary.
School Education Elementary, and the managing director, Assam State Textbook Publication Production Corporation, are required to be issued. It is submitted that presently the officer who is the secretary in the government, secretary to the government in the Department of School Education Elementary, is also holding dual charge as the managing director of the Textbook Publication Corporation. Stop. There is an apprehension expressed that for reasons best known to the authorities concerned, the formal order may not be issued in time, enabling the trust to function effectively as conceived of. Stop. Mr. I. Bodhakur, learned standing counsel, appears for the Textbook Publication Corporation And Mr. P. N. Sharma appears for
Respondent number one, Lord.
respondent number one, namely the Secretary to the Government of Assam, Department of School Education. Stop. Learned councils are permitted. Since the prayer in the writ petition is limited to the extent of issuing a direction to the respondents for issuance of the effective order, this court does not consider it necessary at present to issue notice at this stage. However, learned standing councils are permitted to obtain the required instructions in the matter, and matter be listed on 23rd of February to apprise the court as to why the require effective, why the order as required for giving effect to the so-and-so trust has not been issued by the competent authority as yet. In order to facilitate obtaining instructions in the matter, the the counsel for the petitioner will furnish sufficient extra copies. Mr. Borpuzari for finance.
For respondent three, my lord.
Mr. R. Borpuzari appears for respondent number 3. The copies be furnished within the course of this week. Matter be listed again on 23rd February.
Obliged.
Yes.
Lordship, kindly produce the order dated 19/1/24, Lordship. 19/1/24.
Yes.
Lordship, here I received some instruction. As per my instruction, Lordship, the petitioners have been accommodated as teacher in their respective schools. That list is there,
List 1.
list one, Lordship. Teachers, not as tutor, teachers.
Uh,
They,
What is
They
their
belong to
grievance? What is your grievance?
and they have
Lordship, my grievance
Area
is-
salary.
Yes, area salary as well as regular salary.
No, but you are recommended as teachers now.
Lordship, let them file, give the second copy, Lordship. I'll go and next, on next day, Lordship.
You are not getting your salaries.
My instruction is, Lordship, now some of them already accommodated in fixed pay, Lordship, not all of them, Lordship.
They have been accommodated as teacher, Lordship.
In fixed pay,
No, Lordship,
regular scale.
regular school, they will be,
That-
those who are accommodated as tutor, they will get fixed pay.
So all of them.
Lordship, the list I have received, Lordship, and mostly I have found, and my instruction says, in this regard, I would like to inform that the government had allowed the petitioner in WPC number 47929 of 2017, Jiten Bora and 9 others to accommodate as teacher and under Sibsagar districts, and accordingly, they were appointed as teacher under illegal irregular category. The list of divisional commissioner.
There are 10 persons.
Yes, Lordship. Hard basis, whether fixed pay or the skill.
Teachers,
He says teachers are regular scale.
teachers are in this.
Lordship, there are 4 categories of teachers. Some of them given the fixed salary, some categories I don't know right now. I came to know, Lordship. Let them file affidavit, Lordship.
Those who received salary as well as they underwent training, they are accommodated as teachers.
These teachers have been informed.
They have accepted.
They have accepted. So how is it your clients are aware of it?
Yes, Lordship. But I could not contact for last 6 months.
Right.
We will keep it aside. If you want time for a week, find
Yes,
out
okay.
your instruction.
Let them submit the copy so then I can.
I will.
You furnish a copy.
Lost it.
Learned Council for the parties, Mr. P. N. Sharma, Learned Standing Council, Elementary Education submits that by which report, does the report contain a date?
By communication dated 17th October 2023.
By communication dated 17 October 2023, the department is informed that
With
all the petitioners
Lordship.
have been appointed after proper scrutiny as teachers
Teachers.
in the respective schools
Lordship.
and are being paid given the regular scale of pay
Lordship. Teachers, they get that.
accordingly.
That
The-
regular scale of pay is not there here, not written here, Lordship, otherwise, but teachers get regular salary.
Yeah. are appointed as teachers in their respective schools.
Lordship.
Stop. The Learned Council, Standing Council submits that since they are appointed as teachers, they are likely to get their salaries would be on the basis of a regular scale of pay and not fixed pay. Stop. Mr. Ahmed, Learned Counsel for the petitioner, submits that he would like to complete his instructions from the petitioners in the meantime. He prays that the matter be listed after 1 week. Learned Council, Standing Council will furnish a copy of the list showing the names of the petitioners who are appointed as teachers in their respective schools to Mr. Ahmed. Let the matter be listed after 1 week.
Okay.
Yes.
By last order passed by your lordship, my lord, these matters are fixed today for final disposal. And I am led by the learned advocate general Assam. My lord, let the petitioner start, my lord, we will reply. Today itself, my lord, he is coming.
Lord, we have filed affidavit in opposition, affidavit reply, my lord, against the affidavit. And those are not in the record, my
When did you file it?
lord. Yesterday, my lord, yesterday.
Oh. Why did you file it yesterday when you know that the matters are fixed today?
No, yes, my lord, that's of course. We have taken requisition also, my lord.
No,
Today.
requisition is a different issue. This order was passed
No,
in the
but
presence of
because-
councils fixing the matter
Yes,
today.
of course,
Then knowing fully well, how did you file it without leave of the court? That's the whole purpose, is
Yes, my
to
lord.
defer the matters.
Yes, my lord, yes.
Because you're enjoying some stay order. We'll vacate the orders.
Tomorrow may be taken.
No. Why should we take tomorrow, day after, as per your convenience? We'll vacate the interim orders.
My lord,
You go and file appeal. We'll
No,
vacate
no.
interim orders. This kind of conduct is not expected.
actually, some of petition we have filed last Friday also, my lord.
Uh,
But those things did not come in the record, my lord. Kindly accommodate us, my lord.
We'll accommodate you, but we'll vacate the interim orders.
No, my lord,
When?
that will be evicted, my lord, because here whether the section, rule 18 is maintainable or not in respect of some cases, my lord. In our case, rule 18 is not maintainable, my lord. Only one day time, only one day time.
We are otherwise prepared, my lord.
Only one day time.
Lordship
Only
will
one
hear
day.
the-
One day the heaven will not fall down, my lord.
No, forget about heavens. Let
you also,
leave
my
the
lord.
heavens to us.
Yes,
We'll
we
decide
acknowledge
whether
that.
heavens will fall down or not.
My lord,
We are
acknowledge
questioning your conduct as a council when you know that this is an order
Yes, my
passed
lord. Only
the
one
party
day
in
time,
court and you deliberately file an affidavit yesterday.
my lord, because we have to prepare it, my lord, because against their, my lord.
You chose a date.
My lord,
Date was fixed as per your convenience.
only one day time, only one day time, my lord. Tomorrow may be taken, my lord. Only one day time.
Tomorrow you have to come and do the case. We are not coming.
No, we have already filed, my lord. Only one day time, my lord.
2020.
My lord, let the advocate general come, my lord. Kindly, my lord. Kindly,
You
because we
get
have
a date
prepared.
from him. You get a date from
Only
him.
one day time only. Only one day.
On 20 or 22nd.
No, my lord, some petitioners, my lord, they have filed affidavit in reply today. Now, my lord, if the matters are listed again, my lord, on a date, my lord, I am making it with all respect.
All right, we are deferring it. You give consult a date and inform us.
No, my lord, what they will do, my lord, they will again come in piecemeal basis, my lord, and they will file affidavit in reply,
No,
my
no,
lord.
no, no, my lord, but I undertake my petition, my lord.
No,
We
he
will not,
undertakes,
we
my
will
lord.
not take any more time, my lord.
It is submitted by the Learned Counsel for the petitioners that in WPC so-and-so, 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 certain additional affidavits have been filed. Yesterday, those are not,
So for our case is concerned, we have filed on 5th of.
My lord, we
some
have
of the
received
petitioners have
answer.
filed these affidavits earlier. However, these rejoinder reply affidavits which have been filed with the petitioners are not available in the case records. Although requisition has been sent for, it has not come. Under such circumstances, although the matter was fixed in the presence of the councils, matters will have to be adjourned for the ends of justice, enabling all the pleadings to be made a part of the record. Accordingly, let the matter be listed again on, you give the date. It
My
is
lord,
made
let it
clear,
be.
it is made clear that an attempt, the matter will proceed for hearing on the next date fixed on pleadings as may be available on record. If any of the petitioners seek liberty to file,
22nd.
if any of the petitioners
22nd
seek
to
to
law.
file
2020.
any
20
pleadings, then
2055.
uh,
This is hold the night to side.
liberty is to be
You are-
taken from the court.
Restricted one, then.
Over there. Different.
List accordingly.
My
You
lord,
give a date.
let it be on 20, my lord. In the meantime, my lord, lordship may kindly observe, my lord, it will be taken up for final disposal. Because we have prepared, my lord.
Attempt will be made for final disposal.
Highly obliged, highly obliged, highly obliged.
You have prepared for these matters. The court prepares for all matters.
My lord,
Yet we are inclined to give you adjournment
my lord.
when we would not like to.
Very sorry. Very sorry.
Lordship may, my lord, with all humbleness, my lord, lordship may be pleased to observe, my lord, that in the meantime, my lord, they will complete all their pleadings.
We already
No, because,
filed, man.
no, because, my lord,
What pleadings are necessary here? It's on a question of law.
Yes,
there is a
this
question of law.
those
There- no,
record
my-
also, my lord, we have given as an annexure, my lord. That's
No.
why, my lord.
Are all the counsels available here today
Yes.
in respect of all the matters?
Yes, Lord.
No, we are not asking you about respective matters. We are asking you, are all the
Yes, my
counsels
lord.
present today?
All the-
So are all the pleadings completed?
Yes, my lord.
No further additional
No
rejoinder?
further additional, my lord.
Nothing. All right. Then let
On
us,
20th, my lord.
matter be
Obliged.
listed on 20.
Lordship may kindly be pleased to observe, my lord, that the pleadings are complete, my lord. Otherwise, my lord, next day they will again. Move forward, Dada, please. You stay order, move again.
Since the learned counsels for the parties are available in court, and it is submitted that the pleadings are complete in the matter, let the matter be listed for hearing on 20 February.
Obliged, highly obliged, highly obliged. Highly obliged. Okay, very sorry. Right, please, your lordship. Lordship, on the last occasion, your lordship has directed to bring certain instructions and records, your lordship. In this case, I am praying for further 2 days' time, your lordship.
This is 38.
38.
Yes, your lordship.
What was the issue here?
There is strict observation on last occasion, your lordship.
That voluntary scheme.
Yes, your lordship.
He wants further how
2
much
days'
time?
time, your lordship. Maybe posted on Friday, your lordship.
Can be on Friday. It has to go to 4th of March. Mr. H. Buragohai, Learned Standing Counsel, SBI, submits that what was directed to be produced?
To bring the voluntary retirement scheme of this.
The necessary, that the voluntary retirement scheme
2002 to Bhulpet
of the SBI
2000.
could not be procured. He prays for further time. MS.S. Sharma, Learned Counsel for the petitioner, submits that matter be taken up on a fixed date. Accordingly, list on 4th March. 4th of March.
Lordship, deeply obliged.
So,
Yes, Mr. Ghosh.
here we have filed one additional affidavit. The practice that my lord petitioner filed is a petition for revision of our family pension. And during the process pending of the petition, the bank has paid my lord 8,23,000 something. But our contention is that the ROP rules, the factor which required to be applied here, not appropriately applied. So we have filed an additional affidavit pointing out that as a result, she is still getting the leisure. So, my lord, it is-
I'm waiting reply from my client. Your lordship can fix it after 4 weeks so that we can file if any counter is needed.
It is submitted by You want instructions on what?
My lord, they have filed an additional.
Additional
affidavit.
affidavit, okay. It is submitted by Mr. S.K. Ghosh, Learned Counsel to the petitioner, that an additional affidavit has been filed by the petitioner, Mr. S. Dr. Learned Senior Counsel, appearing for the respondents, seek further time to complete his instructions in respect of the amendments made in the additional affidavit. He prays for 4 weeks' time. Prayer is not objected to by the Learned Counsel for the petitioner, at least after 4 weeks.
Much obliged.
Mr. C.K.S. Borua appears for,
Number one,
who is respondent one?
Department of Home Law.
Respondent one, Department of Home.
Lordship, I am for the respondent number 6 on behalf of Ardhar.
Mr. So-and-so Learned Counsel appearing on behalf of respondent 6. Accountant General,
As he.
Accountant General, on behalf of Mr. Ardhar.
Obliged.
My lord, I am appearing on behalf of B. Gogoi, who is in legs in another court, my lord. We are awaiting of instructions in this matter, my lord.
What is your prayer here?
Lordship, tell it, for time being, Lordship. My senior is also in leg.
Learned counsels for the parties pray for adjournment. Matter stands adjourned at their request.
Fully obliged.
Kindly please the last order.
Last order is at joint request.
Our item is that 43.
Huh? No, this is item 42.
Sorry, Lord.
42.
Unless I am appearing in 42.
Yes.
Well, the small issue involved here is with regard to termination of service of the petitioner. I'm sorry to interrupt. May I please, your lordship? Your lordship, I pray for a short pass arrest. My senior counsel is on his way to the court. For whom you are appearing? PJ Pukan.
We'll hear him. Please inform your counsel to make arrangements to quickly reach the court. We are proceeding on the hearing. Please inform him. Right now.
Highly obliged, your lordship. No, the short issue involved here is with regard to termination of the service of the petitioner during probation period, my lord. My lord, what happened in this matter, he was initially appointed, my lord, he was part of Guwahati University, my lord. Thereafter, the Bhattadev University issued an advertisement for filling of the post of registrar. And he participated in the selection process and he got selected. And he was appointed as registrar of Bhattadev University. Lord, within 4 months, my lord, a conspiracy was hatched by one of the contractor who was my lord, doing development work in the university, that I asked bribe for him for clearing bills, my lord. And he filed a complaint before the ACB, my lord, Anti-Corruption Bureau. And pursuant to that, I was arrested by the Anti-Corruption Bureau. Now, my lord, immediately I was placed under deemed suspension, my lord. No review of the suspension, no subsistence allowance were released. Pursuant to that, my lord, I was granted bail by the Honorable Court. I submitted my certificate of non-engagement, my lord. Everything was done. When there was no review for against the suspension order, my lord, I approached this Honorable Court by filing a writ petition, my lord. And this Honorable Court was pleased to issue notice asking the respondents to submit their reply. In the meantime, my lord, what the respondents have done, they, my lord, took a shortcut and invoked one of the particular provision of the first statutes of the university and terminated the service of the petitioner during his probation period. So that is briefly the case before your lordships, my lord. I'll just take your lordships with the various facts involved, my lord.
Yes.
Lordship will
No,
kind,
there was no inquiry held.
no inquiry held. No inquiry held, a particular provision of statute, my lord, if I take your lordship to the impugn order, it page 51 of the repetition, my lord. This order says,
Yes.
as per resolution number so and so, no date was mentioned, of the Executive Council of Bhattacharya University, and in exercise of powers under section 4.2.2.3, read with 4.2.3.2 of the first statutes, Dr. So and so is hereby relieved from the services of the said university with immediate effect from 1/2/2023. So this was the order passed. I was in probation period for 1 year, and within 1 year, my lord, I was shunted out by passing this order, my lord. So I'll just take your lordships with the papers.
Yes.
If your lordships kindly come to annexure P1, page 31, it's the biodata of the petitioner, my lord.
No, show us the statutes.
Yes,
Provision.
yes. Sorry, my lord.
Is it a part of the pleadings?
My lord, I have quoted, but I am giving a copy of the statutes to your lordship. My lord, comes to page number 1792, top left hand side, my lord.
1792.
92, top left hand side,
Yes.
4.2.2, term of office.
Yes. Yes.
4.2.2.1 says the registrar shall be a whole-time officer of the university who shall be appointed for a term of 5 years from the date of assuming his office. My lord. Then 4.2.2, the registrar may resign from the position of registrar by serving advance notice of 3 months to the vice chancellor. Now this is important, 4.2.2.3, my lord. The executive council may relieve the registrar from the post on recommendation of the vice chancellor. This is important, on sufficient and convincing grounds relating to the dereliction of his assigned duties, gross act of delinquency affecting the administration and functioning of the university, stroke violation of the established rules and procedures of the university, stroke proven act of corruption, financial, administrative, and moral. So your lordships kindly appreciates all these, my lord, conditions or, my lord, stipulations provided in 4.2.2.3 are directed towards conduct of the person concerned. And the next provision is 4.2.3 under the heading conditions of service. 4.2.3.2, the registrar shall serve a probation period of 1 year, which may be further be extended to another year, after which, on review of her performance during the probation period by the vice chancellor, he shall be confirmed in the position for the remaining period of term. Now, within 4 months of his service, my lord, not to speak of 1 year, within 4 months of his service, the vice chancellor, my lord, he put up a recommendation. He prepared a recommendation, my lord. He reviewed the performance of the petitioner within 4 months, and he placed before the EC, and EC passed it, my lord. And those recommendations, my lord, those were produced during the course of the hearing, my lord, proceeding in this matter, and those recommendations clearly reveal that there were allegations of, my lord, misconduct, financial irregularity, all these things, my lord. Without any inquiry, how can you impose this punishment? It's purely punitive and stigmatic, my lord. That is briefly the case.
Yes,
So our submission is that once you rely on this para 4.2.23
yes.
to pass an order to discharge or terminate me, it is automatic or it's inevitable that you are bound to hold an inquiry because the
No,
ingredient of
so. Doesn't say so.
no, that is my submission, Milord, because the ingredient of para 4.2.2.3
On
if
the
your lordship-
recommendation. Is a recommendation
no true.
on
Because
sufficient
it's-
and convincing grounds.
Yes, because the Milord Vice
Your
Chancellor,
submission is that some inquiry is necessary.
some inquiry is necessary.
Before you hold that there are sufficient and convincing grounds.
That is one aspect, Milord. That is one aspect. And what has transpired from the records, from that my submission would be that you are required to hold a full-fledged inquiry, full-fledged departmental inquiry against, because
And
their observations in the recommendations were absolutely punitive.
no, is there a provision of law, rules or statute that what circumstances inquiry is required to be held, conducted?
Milord, they follow discipline appeal rules or some service discipline.
No,
appeal
is
rules.
there anything in the rules to say that for removal from service or the authorities are within their power, are required to, are bound to follow these rules? Or
No.
are ordinarily required to follow these?
That
procedure?
thing, I'll just check up and I'll just come back to your lordship, Milord.
Yes.
In fact, that question came to my mind in the morning hours, Milord. I just,
There is no sort of any appellate forum against this order,
no,
which is the highest body,
EC, Milord.
Executive Council.
Yes. And the impugn order was issued by the VC. So, a bare reading of this para 4.2.3, it clearly reveals that the recommendation of the Vice Chancellor has to be on sufficient and convincing ground. Now, how can you come to a sufficient and convincing ground, conclusion of sufficient and convincing ground, if you are not backed by an inquiry? If I take whatever has been fallen from your lordship, that some inquiry, that was also absent in this case. Relating to dereliction of his her assigned duties, gross delinquency affecting the administration, functioning of the university, violation of established rules and procedures of the university, and proven act of corruption and financial, administrative, and moral. They acted upon on this last particular line. But I'll just take your lordship, hand over your lordship to the recommendation of the but I'm sorry, Milord, these were photocopied from my copy, Milord. There may be some marks, Milord. I'm extremely sorry for that.
No issue. Where is the agenda?
Agenda in the next bunch of paper, Milord. Minutes of 8th Executive Council meeting, your lordship will find. There are two set of papers.
Okay.
First is the Milord assessment of performance, Milord. This was the assessment of performance made by the VC, Milord.
You were caught red-handed.
No. Milord, what happened in this matter? I was traveling, Milord, that is also a checkered history. Milord, if I take your lordship from the FIR onwards, Milord, what happened in this matter? I was on an official tour to meet some officer in the secretariat, Milord. It was absolutely a Milord false trap laid by the contractor along with the ACB officials, Milord. When I was traveling, Milord, in San Mari, I was intercepted by a vehicle of person, Milord. I was taken out of my car and I was inserted in the vehicle of those person and I was taken to a house in Chanmari. in an apartment. Till then, I did not know who were those persons, my lord. Later on, I came to know that those were the ACP officials, my lord. In fact, if your lordships kindly have a look at the FIR, this FIR, my lord, gives ample description that this was absolutely a false trap. I'll just take your lordships to the FIR for a moment, my lord. Lordship will kindly come. May I take your lordships in the order of the annexures, my lord, right from his date of initial appointment and all.
Yes.
The first thing, annexure P1 is the academics of the petitioner and his career graph, my lord. Page 31, my lord.
Yes, page 35.
Page 31, my lord. Annexure P1 is the academic and career graph of the petitioner.
Why don't you take us through the
Yes, my
report?
lord.
Why don't you
He
take
was-
us through the
he-
report? Because you see, we are not, no one is questioning his career graph.
No, just for a minute, just for the beginning of the matter, my
No,
lord,
but the allegations here are found to be very serious.
yes, my lord.
Now, there are two views to that. One is that what is the status of the FIR and all that? Charge sheeted. Trial going on. The other is that there was some inquiry made by the university into the veracity of the allegations itself. So you take us through that only because
Fine, my lord.
you are challenging the removal from service.
Yes, termination of my service during probation period. That's
Yes.
annexure P2, page 36, my lord, is the order, office order by which, my lord, I was given lien by the Guwahati University for my appointment as Registrar Bhattadev University for 2 years.
Hmm.
It is
Lien.
lien, my lord, because I was there in Guwahati University as academic registrar with effect from 25/10/2016. Thereafter, my lord, I got appointment as registrar and this was lien 5/5/2002 with effect from, and it was for 2 years, my lord. Now then comes the FIR, my lord.
Yes.
FIR page 39, my lord. My lord will kindly come to page 39. If I may read, my lord. With reference to the subject cited above, I have the honor to inform you that I am a contractor under PW department in the month of last February 2022. Lordship will mark last February 2022. I got work order of art filling of so-and-so university, so-and-so. The total amount for the work order was so-and-so. Subsequently, I partially completed the work. Against the completed work, the executive engineer so-and-so prepared a running bill of 43% of the total work, amounting so and forwarded the same to the registrar of the so and so. But the said registrar kept the bill pending for last 2 months without any reason. In this regard, I met him several times, but did not release the bill. Later on, he demanded an amount of rupees so and so against the bill. Subsequently, when I expressed my inability to pay such amount, he reduced the demanded amount to 50,000. As I was not willing to pay bribe, I recorded the bribe demand conversation on so and so in an electronic device. And when I met him, he again demanded bribe. So I lodged the FIR at Vigilance and Anti-Corruption Department with request to you initiate necessary lawful action against the said for a public servant as applied. My lord will kindly have a look that this incident happened on 6/8/2022, and the background of this incident, my lord, I have stated in my writ petition at
You have not, have you challenged the criminal proceedings, inquiry, nothing?
No, that is going on, my lord. Because ultimately this was the proceeding because of which, my lord, he was terminated. Then he was granted bail by the court, page 41 annexure P4.
Now, let us assume that all the other allegations against you are not correct. There are allegations of you dereliction of duty, not providing, not recording the tour register, the tour diary, this, that. On the basis of the report given by the ACP and the allegations against you, what was the university required to do? Can the university embark on an inquiry to find out whether these allegations are essentially correct or incorrect? Nothing. Because it's a matter of criminal investigation.
No, normally what happens, my lord, if a criminal proceeding is going on, they don't proceed with DP. They see outcome of the criminal proceeding or they expedite the criminal proceeding normally. And it is also law that there is no bar for holding a DP.
There is no
They
bar.
can initiate
no
departmental proceeding, but they cannot take a shortcut and get rid of an employee in this manner.
You are not just any employee, you are the registrar of the university.
True, my lord. My lord, I joined as registrar.
You are in charge of the administration.
True, my lord. I joined as registrar on 6/5/2022. It was only 4 months in the university. Lordships may not get influenced by whatever happened in the FIR because
We are
that
not
is a checkered
influencing.
history.
We are not being influenced. We are just thinking aloud.
Yes, yes.
Sharing our thoughts with you.
Absolutely
We have not
correct.
taken a call on whether your petition is to be allowed or dismissed.
No.
What we are trying to understand is, in a given set of facts, an officer of the university against whom there are serious allegations is taken into custody.
What will happen?
What options or what procedure is available before the authorities?
Well, the procedure is that they can go for a departmental proceeding.
No, now
and
let us see your criminal proceeding. When was the FIR filed?
FIR filed on 6/8/2022.
22.
Yes, I was
Now-
placed under suspension on 9/8/2022.
Right. So now the matter, as per the respondents, is at the stage of charge sheet. Trial has commenced.
Charge sheet has been filed.
It's been filed. So trial has commenced. Now, assuming you are kept under suspension, you will not be allowed to perform the duties of a registrar.
That's a different thing altogether. I understand, my lord. If this termination order goes, the suspension remains. That's absolutely fine. But this the order of termination on the teeth of the provisions and whatever has been the law holding the field in this regard is absolutely illegal, my lord. You cannot get rid of a person alleging misconduct against him that he committed financial irregularity, he committed misconduct. You cannot get rid of a person on the background of these allegations by
Without
passing an order of termination simpliciter.
Without confronting him with these allegations.
Yes, my lord. You cannot, my lord, because in fact, if their stand in their affidavit is that it is a termination simpliciter. So the criminal case pending against him did not actuate the order of termination. But the fact is that the moment you invoke this provision 44.2.2.3, that itself gives an idea that you can discharge him from service only on the ground of alleged misconduct. All the ingredients are of misconduct. And they are taking a plea that 4.2.2.3 has to be read harmoniously along with 4.3.2.3, which is a condition of service. You can review my performance only after 1 year. I completed 4 months of service. In the meantime, I got arrested. And I filed a writ petition before this honorable court praying for setting aside of my suspension. No substances allowance was paid. Instead of defending that suspension, immediately you come up with a order saying that no, we are invoking these 2 provisions. You are out from service, Milo. Can this be done in the manner and in the background of the records that were placed before your lordship? Because records clearly reveal that the VC recommended that there were financial misappropriation by the petitioner.
Hmm.
There were integrity doubtful also. If you lordship kindly come to agenda number 19.
Yes.
In the middle portion, Milo. At least I am entitled for right of hearing. If I have done something wrong, initiate a departmental proceeding. Within a month, you complete it. Despite pendency of criminal proceeding, you can hold DP. Agenda item number 19, in between, my lord, middle. The line starts with the house was further informed.
No, you read the entire.
I'm reading, yes. The house was of the view that the presence of the regular registrar is essential for the effective functioning of the university. Thus, it had a threadbare discussion to consider if Dr. So-and-so on probation, who is presently under suspension in view of his arrest on so-and-so in connection with so-and-so, should continue in the said post of registrar on probation of the university. During the course of the discussion, the House was apprised that so-and-so joined the registrar on probation on so-and-so, but he is still holding his lien in Guwahati University. Further, the House has been apprised by the Honorable Vice Chancellor about his own assessment performance by Sri so-and-so as probationer from so-and-so to so-and-so. Several instances which occurred during the said tenure have been brought to the notice of the House, wherein the Honorable Vice Chancellor had to intervene regarding the actions of Dr. So-and-so during the 3-month service period under probation to ensure smooth functioning of the administrative machinery of the university. Details of several instances in which deed and registrar's action was found inappropriate were presented, read out to the House in the form of various office notes. The House was further informed about the instances of irregularities in financial matters on the part of the state registrar, which are evident in the official notes of the Vice Chancellor aimed at making Sri so-and-so to discharge his duties properly. The House noticed the administrative lapses of Sri so-and-so, which delayed important matters which needed to be taken care of promptly in the interest of the university, which is at its nascent stage. All these factors, circumstances led the House to the unanimously concluded that the so-and-so's performance during the probation period was not satisfactory, and as such, he is not suitable to continue in the post of registrar. The House discussed the provisions of the statute with a view to dealing with the situation in larger interest of the institution. In this regard, the House was apprised of the legal opinion received from Standing Council of the University on the feasibility of relieving Sri so-and-so from the said post during his probation period. The House went through the legal opinion of the Standing Council, read and deliberated upon the provisions under section so-and-so of the first statute in detail, and upon much deliberation decided to relieve Sri so-and-so from the post of registrar so-and-so with immediate effect in the interest of the university. The House also had a threadbare discussion in the matter of advertising for the post of registrar, keeping in view the need of a permanent registrar to take care of the administrative matters of the university. However, suggested to take opinion from the Sending Council of the Guwahati University. Resolution. The Executive Council, Bhattadev University, unanimously resolved to relieve Sri so-and-so from the post of registrar of this university with effect from so-and-so as per provisions under so-and-so of the first statute on the ground that his general unsuitability to hold the said post, and it further resolved that he be released from service of so-and-so on the same date through a written communication. The House further resolves to direct the registrar IC to initiate the process of advertising for the post of registrar after consultation with the Standing Council of the Guwahati University. Now, I'd like to read, Milord, para 18, Milord, agenda 18 also. Same the Executive Council meeting in the previous page of para, Milord, agenda 19. Same Executive Council meeting, there was another decision.
You're referring to?
Agenda item number 18.
Yes. Okay. Yes. Please read.
Yes, Milord. Regarding the court case filed by so-and-so suspended registrar against the university. The registrar IC informed the House about the court case filed by so-and-so suspended registrar against the university seeking reinstatement in the post of registrar. It was brought to the notice of the House that EC in its 16th meeting held on so-and-so resolved to continue with the proceedings regarding the issue in pursuance of the letter received from so-and-so dated so-and-so. The House, after prolonged discussion, decided to stick to its earlier resolution taken in this matter and directed the registrar to consult the Standing Council for the council for following up in the matter in the court. Resolution. The Executive Council unanimously resolved to direct the registrar IC to proceed legally in consultation with Standing Council against the court case filed by Sri so-and-so. So on the same meeting, one decision it was taken that will proceed legally in the matter with regard to suspension, and same day, Milord, meeting another resolution page agenda item number 19 that they will terminate my service by invoking those provisions. And in the meantime, Milord, they got the opinion of the Standing Council also.
Yes. Yes.
Yes, I'm just thinking.
This is not a part of the records.
Milord, what happens during the course of the hearing, Milord, deliberation, the respondents were directed to furnish the, produce the records before your lordship and hand over a copy of the same to us also. Pursuant to this, Milord, we have filed an additional affidavit also.
Enclosing this.
Yes, Milord. Milord, in the additional affidavit, it was not enclosed, but I think those records were there before your lordship. Records. It is a part of the records. My friend has got the record.
All right. Yes. So
and if your lordship,
your basic thrust on the arguments is that there was no proceeding initiated against you and you were terminated on the basis of certain allegations which have been found to be proved without confronting those allegations, without confronting you with those allegations or giving any opportunity.
yes,
And
those were the motive, Milord, those were the
and this is
foundations.
apparent, besides others, it is apparent from the resolution itself that they wanted to proceed with some departmental proceeding.
Yes.
Which, however, they took a
Shortcut.
U-turn.
Yes.
In the next agenda.
Yes.
Okay.
In fact, if your lordship considers the assessment of performance by the VC, it speaks loud about several allegations of misconduct.
Yes.
Second page, Dr. So-and-so would often abstain from his duty as registrar so-and-so without leave, prior permission. In one such instance, he did not submit an application for admissible leave even when the undersigned directed him to do via email. Then serial number 4. The complainant Sri so-and-so oversaw the chairman as the chairman of the auction committee, the auctioning as substantial amount of scrap iron material, and by keeping the vice chancellor,
Yes, yes, yes.
keeping the vice chancellor in dark, deposited the sale proceeds into a bank account of the university of his choice. When reminded of lack of transparency, he argued that he thought the head assistant had or would inform the vice chancellor of the auction process and obligor regarding fund generated through auctioning. Serial number 5. In yet another instance of financial irregularity, Sri so-and-so of his own reinvested the maturity value or originally invested amount of so-and-so without taking approval of vice chancellor, thus leaving room for audit objections in future. Then 7, lack of responsibility displayed also for some force when he refused to write his 2 diaries mentioning kilometers traversed by him on official duty and also the days on which he took the official tips for which he needed to spend for the purchase of diesel fuel to run the vehicle used by him. He refused to draw advances to be made available by the university for the purchase of fuel for the official vehicle and instead submitted a series of dubious looking cash memos mostly collected from counters of the fuel pump instead of electronic receipts that could be obtained directly from the pumps. Some of the receipts and patterns of expenditure indeed look absurd, and reimbursement against such bills are extremely hard to make.
Yes.
Then there are several instances, Miller. Finally, in the last paragraph, he records that having considered the responsibilities and decorum which is expected from the post, I am of the considered view that the further retention of Sri so-and-so in the post of registrar of the university would not be beneficial for the university on the ground of general unsuitability to hold the post in question. Further, Sri so-and-so is on probation, therefore relieving him from the post of registrar at this stage without commenting on the veracity of the allegations or without raising questions to his character or conduct, and by keeping the better interest of the university in mind, would not hamper in future prospect in any manner. I would, in view of the above, recommend that the probationary service of Sri so-and-so at registrar to be discontinued in the interest of the university, considering his general unsuitability to hold the post while ensuring his liberty to go back to the Guwahati University as still he holding lien therein. So he recorded and all the misconducts in his findings, Milord, from serial number 1 to 14. There are several instances wherein allegation of financial irregularity level, insubordination leveled, integrity was doubted, and finally to give a picture or to give an impression that it is termination simpliciter, he records that it is general unsuitability. Now, the question that comes is whether on the teeth of these allegations, this termination can be said to be termination simpliciter on the ground of general unsuitability. Now, we have filed an additional affidavit
Yes.
this additional affidavit was filed after they produced the records before this honorable court. And it contains that the submissions that I have made right now before your lordships, my lord. Additional affidavit filed on 25/4/2023, my lord.
Yes,
Lordships, got. At para 1, your lordship will find the,
additional affidavit,
yes, ma'am.
not reply.
It was filed on, my lord, 25/4/23.
Twenty-fourth February.
Yes, ma'am.
Yes.
25th of April, my lord.
Hmm?
My lord, it will be
24th
it is
of
like-
February.
25th of April, my lord, 23. Lordship, sir.
Yes.
Lord, para 1, your lordship will find the order by which this honorable court directed to produce the relevant records, and they produced, my lord.
Hmm. Yes.
Lord, para 2 onwards are the, my lord, our submission with regard to those records, my lord. I'll directly take your lordships to para 4, my lord.
Yes.
May I read, my lord? That the petitioner begs to state that the assessment of performance that is so and so done by the Vice Chancellor of Bhattacharya University on its own is sufficient to derive conclusion that the termination of service of the petitioner as registrar assessing 3 months of his probationary service is punitive. A bare perusal of the various instances narrated by the Vice Chancellor clearly demonstrate that the foundation of the recommendations of the Vice Chancellor are based on misconduct and negligence, which ultimately culminated into the decision of the Executive Council to terminate the service of the petitioner. At serial number 4 and 5, the VC alleged about financial irregularity by the petitioner. At serial number 13, the dereliction of duty by the petitioner was conceived and concluded. Again, all the shortcomings narrated and relied on by the VC, even assuming not admitting those to be correct, to make the recommendation of termination of service of the petitioner were absolutely subjective without giving an opportunity to the petitioner to improve upon those shortcomings. Therefore, when the foundation of the recommendation of the Vice Chancellor was based on negligence and misconduct of the petitioner, the consequential decision of the Executive Council is absolutely punitive in nature. The Vice Chancellor totally misconstrued the law holding the field of termination during probation. The Vice Chancellor thought that an innocuous conclusion in the recommendation dated so and so would make it a case of termination simpliciter, overlooking the various instances of misconduct and negligence. The lack of objectivity in the decision-making process, wherein decision have been arrived at without giving an opportunity to improve upon shortcomings, is also punitive in nature. This is nothing but poor understanding of the VC when he considers the allegations of serious negligence and allegations of misconduct to be general unsuitability to clothe the order of termination with a termination simpliciter forward. Then para 5, my lord.
That's okay.
So this is
these are essentially the basis of your arguments.
Yes, my lord. These are basically, my lord, the written form of the oral submissions that I have made before your lordship.
Hmm.
Now, what the respondents say in their affidavit, my lord. University's affidavit Lordship will find running page 52. Para 5.
Yes.
That with regard to the statements made in para 33 of the writ petition, it is respectfully stated that there is no restraint order operating in WBC so and so which departs the competent authority from assessing the performance of the petitioner during his probation period. Accordingly, such performance was assessed as per the law governing the field, and thereafter, the petitioner has been relieved from service on the ground of his general unsuitability, right order dated so and so. So they say that all these misconducts and financial irregularity, integrity doubtful are general unsuitability. Now, para 6, my lord, they have admitted that with regard to the statement made in para 34, 35 of the writ petition being misconceived and baseless, the answering respondent categorically denies the correctness of the same. In this regard, it is humbly stated that the protection under Article 311(2) of the Constitution of India would be available to a government servant only when his removal from service is relatable to some misconduct. In the case at hand, the petitioner has not been relieved from service for any misconduct. The competent authority assessed the performance of the petitioner during his probation period and found him to be unsuitable for continuing in the capacity as registrar of the university. As such, the petitioner has been relieved from service by order dated so and so. It is stated that the petitioner has neither been released for his involvement in his so and so, nor as a punitive measure for his involvement in the said criminal case. Needless to say that the petitioner is holding lien in his substantive post of academic registrar in Guwahati University and is free to join that post. Para 7, my lord. That the statement made in para 36 to 40 of the writ petition being wholly misconceived and baseless, the answering respondents categorically denies the correctness of the same. A contention is sought to be advanced by the petitioner as if section 4.2.2.3 of the first statutes can be invoked by the authorities to relieve the incumbent registrar from service only in cases of dereliction of assigned duties, gross act of delinquency affecting the administration and functioning of the university, violation of the established rules and procedures of the university, and proven acts of corruption, financial, administrative, and moral. Further, it is contended that the aforesaid grounds being relatable to a misconduct on the part of an employee, a departmental inquiry is a sine qua non for removing such employee on such ground. The same having not been done, the impugned release order dated so and so is violative of Article 311(2) of the Constitution of India. In this regard, the answering respondent respectfully begs to state that apart from the above mentioned grounds, an incumbent registrar can be released in terms of the grounds enumerated in section 4.2.3.2 of the first statute. The said provision stipulates that the vice chancellor of the university can assess the performance of the registrar during his probation period so as to arrive at a satisfaction regarding his future continuance or not. Upon such assessment, the service of the registrar may either be confirmed or he may be relieved from service by the Executive Council on the recommendation of the Vice Chancellor. Hence, the ground enumerated in section 4.2.3.2 has to be harmoniously read with section 4.2.2.3 of the first statutes. Further, it is no longer res integra that an act of releasing a probationer from service on the ground of general unsuitability does not attract the vice of Article 311(2) of the Constitution of India. Coming to the case at hand, the petitioner admittedly joined the registrar of Bhattacharya University on so and so and served in the said capacity till 5/8/2022. The petitioner was arrested on so and so in connection with so and so after being caught red-handed while accepting bribe. Accordingly, he was placed under suspension by order dated so and so under rule so and so. Be that as it may, a perusal of clause 7 of the petitioner's appointment order, along with section 4.2.3.2 of the first statute, would reveal that the first year's petitioner's service would be under probation. That being the position, the Vice Chancellor assessed the performance of the petitioner during his probation period and thereafter placed his recommendation before the Executive Council in its meeting held on so and so. In the said meeting, the Executive Council was also apprised about the various instances where the petitioner failed to render his duties in a desired manner, hampering the interest of the university, which is at its nascent stage, and started functioning from so and so. Upon much deliberation and considering the materials available on record, the Executive Council resolved to relieve the petitioner from service on account of general unsuitability to hold the post of so and so. As such, in terms of the said resolution, the impugn order dated so and so has been issued, relieving the petitioner from service with effect from so and so. Therefore, the attempt on the part of the petitioner to portray that the impugn order dated so and so as bad in law by solely relying on section so and so and ignoring so and so of the first issue does not hold water and resultantly warrants rejection at the hands of the honorable court.
Yes.
Now, if your lordships kindly come to the appointment order, page 62 of that particular affidavit itself.
In the affidavit.
Yes, my lord. The affidavit, just lordship has read, my lord. Page 62, my lord, running page.
62.
Annexure A of the affidavit of the university. No, the affidavit that I read, my lord.
Yes, 25/4 to 22. 25/4/22.
No. 14/3/23. 14/3, my lord, the affidavit that I am reading just now, my lord. The annexure appended to that affidavit only.
So the appointment order is dated 25/4/22. Appointment
You're
order.
pointing out the appointment order.
Yes, my lord.
What is the date?
25/4/2022.
That is what we just said.
Oh, I'm sorry, my lord. It's running page 62.
In our copy, it is 100 something.
Oh,
104.
sorry, my lord. Extremely sorry. My lord, it contains the clause of the provision down below, para 7. You will receive a probation, you will serve a probation period of 1 year, which may be further extended to another year. After which, on review, your performance by the Vice Chancellor, you will be confirmed in the position for the remaining period of term. And if we read this particular condition in the appointment order, along with the statutes, that is para 4.2.3.2.
That's the to consider.
If your lordships kindly take the statutes for a moment again.
Yes.
It says, firstly, this 4.2.3.2 comes under the heading conditions of service below. The registrar shall serve a probation period for 1 year. The registrar shall serve a probation period of 1 year, which may be further extended to another year. So he'll serve for 1 year, and your business of assessment of the performance will come only after 1 year. After which it specifically provides.
You want to say that until 1 year is not completed,
Yes.
there can be no review
Yes, my lord.
of the provision of the provision.
Yes. It says the registrar shall serve a probation. My lord, if you want to assess a person, you need to give him some time. Within 4 months, how can you review a person? So that is the mandate of the whole thing here.
All right.
It says that the registrar shall serve a probation period of 1 year, shall serve, which may be further extended to another year. That means he'll serve for 1 year and you will do your exercise of review of his performance. Then the question of extension comes. After which, that is after 1 year, on review her performance during the probation period by the Vice Chancellor, he shall be confirmed in the position for the remaining period of term. So this is another violation.
Yes.
They are saying that 4.2.2.3 has to be harmoniously read with 4.2.3.2,
Yes.
clearly reveals the modus operandi behind me. The motive, I'll not say the foundation behind. So their entire thing is that he was arrested. In fact, that was also a Milord pre-planned trap. I'll not go into all those things, Milord. Let that be decided in the criminal court. He was arrested and there were serious allegations. The petitioner had an, Milord, discourteous relationship with the vice chancellor, Milord. That's why we have made him a party and we have leveled serious allegation of misconduct, Milord. Sorry, serious allegation of malafide. I'm not going into all these things, what were the allegations of malafide, but it is a fact that the petitioner submitted complaints with regard to several recruitment process undertaken by the respondent number 8. In key positions of the university, the VC wanted to appoint some persons who did not have the qualification. The petitioner objected to those, all those things are there. But even without going into all these things, I was placed under suspension. You did not review the suspension after 90 days. You did not release the subsistence allowance. Till November you released, thereafter you stopped. I approached this honorable court, questioning my suspension. Notices were issued. And immediately you come up with an order saying that by invoking 4.2.2.3 and 4.2.3.2, you were relieved from service. Lordship will also mark one important aspect of the matter. The impugn order, there is no whisper that the petitioner was terminated from service for general unsuitability. Lordship will kindly come to the impugn order again. It doesn't have a single letter. In their affidavit, they tried to improve their case. No, it's a case of general unsuitability. We are not actuated by his involvement in the criminal case. Fine. But that has to be incorporated in the impugn order. MS Gill, my lord. You cannot improve.
Yes.
The impugn order said, in exercise of power under so and so, is hereby relieved from service of the said university with immediate effect. Does it say anywhere that for unsatisfactory service? Nowhere. And law also demands that even you terminate a person for unsatisfactory service, before coming to this conclusion of dissatisfactory service, you are required to give him opportunity to improve upon his shortcomings while he was in service. Because any decision has to be objective. Article 311(2)(c) only gives scope to take a subjective decision when it's a case of interest of security of the state. In all other cases, my lord, it's a settled provision of law that your decision has to be objective. Objective means it has to be based on some material, wherein I was given chance to improve my shortcoming. No opportunity. So on the face of it, it is apparent that my termination was not due to unsatisfactory service because the termination order did not say so. And mere reference of the section 4.2.2.3 depicts that I can be terminated only on the ground of misconduct. And if you turn on this 4.2.2.3, a disciplinary proceeding is must. But one order I would like to take,
One minute.
I'm
Please
sorry.
come back to
4.2.2.3, my lord.
4.2.3.
4.2.2.3.
Hmm.
The Executive Council may relieve the registrar from the post on the recommendation of a Vice Chancellor. Milord, Vice Chancellor, Milord, registrar post is not a grade 4 post, Milord. That's why some protection is given in this section itself by the Vice Chancellor on sufficient and convincing ground. Milord, it is my pleaded case in the writ petition that to arrive at sufficient and convincing ground, you need to have a inquiry. Maybe any kind of inquiry you undertake internally, that is for you to do.
Okay.
Relating to dereliction of his or her assigned duties, gross act of delinquency, affecting the administration functioning of the university, violation of the established rules and procedures of the university. Lord, this is very important. Proven act of corruption, financial, administrative, and moral. Proven act. Where is the proof? You yourself, Milord, there were allegation of financial irregularity. You yourself assessed, you yourself recorded. Where is the proof? So from this, Milord, two limbs of argument. Firstly, that for arriving at the conclusion of sufficient and convincing ground, you need to have a inquiry, some. And next limb is that if you want to invoke this provision, then the element of misconduct automatically comes. And from your records, it reveals that you terminated my service during provision on the ground of alleged financial irregularity and there were doubtful integrity. Assessment. But I'm
Yes.
relying on to Milord, I just wanted to place one order, the first order of this honorable court in this matter. Order dated 10/2/2023. No. It was passed in the writ petition. আপনি মোক মৰম কৰে কাৰণে দিছিল মোক পূজাৰ লগে লগে আপনি দি
10-2. You're referring to 10-2.
10 to me. The court order.
Yes, yes.
My lord, this is with just to give a brief background. Your lordship will kindly have a look.
You want to point out to the order for what?
My lord, why I am referring to this because in the meantime there was an advertisement issued by the respondents to fill up the post of registrars by holding selection that was stayed by this honorable court. So this is a subsequent development that lordships I think like to take note of.
So as on date, it's run by an in-charge university,
In charge.
in-charge registrar.
In charge. Para 8 onwards, your lordship would like to see. Para 8 onwards.
Yes.
I have heard the learned counsel for the party. The senior counsel appearing on behalf of the petitioner have submitted that the bare perusal of section so and so read along with the order dated so would clearly go to show that the action taken by the executive council by the order dated so is punitive and stigmatic in nature and as such same violates the provision of article 311(2) of the constitution of India read along with the provisions of Assam Service Disciplinary Appeal Rules 1964. We further submitted that a perusal of the section so clearly shows that the executive council can relieve the registrar from the post on recommendation made by the vice chancellor on sufficient and convincing ground relating to dereliction of his her assigned duties, gross act of delinquency affecting the administration functioning of the university, violation of established rules and procedures of the university, proven act of corruption, financial, administrative, and moral. Taking into account that in the order impugned, the Executive Council have taken action by taking recourse to clause so and so. It clearly amounts to an action being taken without putting the petitioner to notice or even without an inquiry being carried out, as is required under the provisions of Articles 311(2) of the Constitution of India, read with rules of 1964. He therefore submitted that the said order needs to be interfered with and stayed pending disposal of the writ petition. Then, my lord, the submissions of the councils were recorded. Then your lordship will kindly come to the operative portion. Para 17. This court also needs to take note of the post that is a very important post in the respondents.
Yes.
First ordinance and first regulation of respond number 3. This aspect of the matter could be seen from perusal of section 4.2, which stipulates the registrar is the chief administrative officer. Lord, I'm sorry, I just wanted to point out the stay order passed by this honorable court. Para 16, my lord. Para 16, I'm sorry, my lord.
Okay.
On the question of balance of convenience, this court also finds it relevant to take note of the submissions made by the Learned Counsel for the appearing on behalf of the respondent so and so, wherein he had submitted that instead of granting an absolute stay of the advertisement, this court made, taking into account that the process of selection being time consuming, may direct the respondent authorities not to declare the result. This court is of the opinion that the advertisement is at a nascent stage, permitting the respondents to go ahead with the process of selection at this stage would not be in the interest of justice, as it would not only be unnecessary exercise, taking into consideration that the issue of relieving the petitioner is presently pending before this court, but it would also involve creation of certain third-party rights and leading to complexity of the matter. Under such circumstances, this court is of the opinion and accordingly direct the respondent authorities, more particularly the respondent number 3, 4, 5, not to further proceed with the said advertisement dated so and so, published in newspaper so and so, till disposal of the writ petition. So this was the interim order passed by this honorable court.
Yes.
Well, I'd like to rely on some judgments of this honorable court, of the honorable apex court in this regard.
Yes.
I'm just giving the relevant paragraphs I'm relying on, and I'll read 3 paragraphs only here. The relevant paragraphs are, my lord, I'm sorry, 2005 SCC 152.
2005 SS.
2005 SCC 152.
Yes.
Names of the parties: Chandra Prakash Shahi versus State of UP and others.
Yes.
My lord, the relevant paragraphs that I'll rely on is para 12, 13, 16, 17, 19, 21, 22, 23, 24, 26, 28, 29, and 31. The ratio, lordship will find in page 20, para 24, 26, and 28. May I read? Para 24, my lord.
Hmm.
In Ravindra Kumar Mishra versus UP State Handloom Corporation Limited, it was held that for finding out the effect of the order of termination, the concept of motive and foundation has to be kept in mind. It was further observed that no straitjacket test can be laid down to distinguish the two, namely motive and foundation. Whether motive has become the foundation has to be decided by the court with reference to the facts of the given case. It was also observed that the motive and foundation are certainly 2 points of one line, ordinarily apart, but when they come together, motive gets transformed and merged into foundation. It was also observed that since in regard to a temporary employee or an officiating employee, an assessment of service is necessary merely because the authority proceeds to make an assessment and records its view, it would not be available to be utilized to make the order of termination following such assessment punitive in character. It was observed by this court that in the relationship of master and servant, there is a moral obligation to act fairly. There should be an assessment of work of the employee, and if any defect is noted in his working, the employee should be made aware of the defects in his work and deficiency in his performance. Defects or deficiency, indifference or indiscretion may be with the employee by inadvertence and not by incapacity to work. Timely communication of the assessment of work in such cases may put the employee on right track. Without any such communication, it was observed it would be arbitrary to give a movement order to the employee on the ground of general unsuitability. Lord, it says that if you are recording something adverse against any person during probation period, you need to give him opportunity that, look, these are the points wherein you are lacking. You need to improve up. During probation period itself, if he fails to improve up, say for example, in this 1 year, in this case 1 year, after the 1 year period, you take a call that he was appointed on so and so date, and he was lacking in this point. I gave him opportunity and he failed to improve. So it's a case of unsatisfactory service. His service was not satisfactory. Then para 26, my lord. In Radhesam Gupta versus UP State Agro Industries Corporation Limited, which is related to a probationer, the whole legal position was reviewed by brother Sri so-and-so J in an illuminating and research-oriented judgment. And after considering various decisions, including the decision in Kaushal Kishore Shukla case and a still later decision in Commissioner of Food and Civil Supplies, Lucknow, UP versus Prakash and Saxena, so as to trace the development of law relating to this aspect of service jurisprudence, laid down that there has not been any conflict of opinion inter se various judgments, including those laying down the motive and foundation theory. It was held that the question whether the order by which the services were terminated was innocuous or punitive in nature had to be decided on the facts of the case, each case after considering the relevant facts in the light of the surrounding circumstances. The benefit of protection of Article 311(2) of the Constitution is available not only to a temporary servant, but also to a probationer. And the court in an appropriate case would be justified in lifting the veil to find out the true nature of the order by which the services were terminated. Now, para 28, my lord. The important principles which are deducible on the concept of motive and foundation concerning a probationer are that a probationer has no right to hold the post and his services can be terminated at any time during or at the end of the probation period on the ground of general unsuitability for the post in question. If for the determination of suitability of the petitioner of the probationer for the post in question, or for his further retention in service, or for confirmation, an inquiry is held, and it is on the basis of that inquiry that a decision is taken to terminate his service, the order will not be punitive in nature. But if there are allegations of misconduct and an inquiry is held to find out the truth of that misconduct, and an order of terminating the service is passed on the basis of that inquiry, the order will be punitive in nature, as the inquiry was held not for assessing the general suitability of the employee for the post in question, but to find out the truth of the allegations of misconduct against that employee. In this situation, the order will be founded on misconduct, and will not be a mere matter of motive. Para 29. Motive is the moving power which impels action for a definite result. And to put it differently, motive is that which incites or stimulates a person to do an act. An order of terminating the service of an employee is an act done by the employer. What is that factor which impels the employer to take this action? If it was the factor of general unsuitability of the employee for the post held by him, the action would be upheld in law. But if, however, there were allegations of serious misconduct against the employee, and a preliminary inquiry is held behind his back to ascertain the truth of those allegations, and a termination order is passed thereafter, the order having regard to other circumstances would be founded on allegation of misconduct which were found to be true in the preliminary inquiry. Lastly,
Yes.
applying para 30 Milo, applying these principles on the facts of the case, it will be noticed that the appellant who was recruited as constable in so and so had successfully completed the training and has also completed 2 years provision period without any blemish. Even after completion of the period of provision of the so and so, this will not be required. So the ratio is up to para 29. So in the touchstone of the provisions in the first statute,
Yes.
no inquiry and allegation of misconduct. In both the counts, the ratio laid down by the Honorable Apex Court clearly reveals that the impugn order is absolutely unsustainable in the eye of law. If you find that the allegations of misconduct is there, the order is not termination simpliciter, it's punitive. If you hold an inquiry to ascertain the veracity of the allegations are misconduct, then also it is a case of, and if you don't initiate a proceeding, it's a case of punitive order of termination. The next judgment I'm relying on is 1984 2 SCC 369. Anup Jaiswal, 1984 2 SCC 369. Anup Jaiswal versus Government of India and another.
Yes.
The relevant paragraphs will be paragraph 12, 13, and 15.
Yes.
Para 12. It is therefore now well settled that where the form of the order is merely a camouflage for an order of dismissal for misconduct, it is always open to the court before which the order is challenged to go behind the form and ascertain the true character of the order. Even in our case also, my lord, the order, impugn order even doesn't say that your service was terminated for unsatisfactory service. So this honorable court had the occasion to go beyond the order and see the resolutions and recommendations. If the court holds that the order, though in the form, is merely a determination of employment, is in reality a cloak for an order of punishment, the court would not be debarred merely because the form of the order in giving effect to the rights conferred by law upon the employee. Then para 13. In the instant case, the period of probation had not yet been over. The impugn order of discharge was passed in the middle of the probationary period. An explanation was called for from the appellant regarding the alleged act of indiscipline, namely arriving late at the gymnasium and acting as one of the ring players on the occasion, and his explanation was obtained. Similar explanations were called from other probationers, and enquiries were made behind the back of the appellant. Only the case of the appellant was dealt with severely in the end. The case of the other probationers who were also considered to be ringleaders were not seriously taken note of. Even though the order of discharge may be non-committal, it cannot stand alone. Though the noting in the file of the government may be irrelevant, the cause for the order cannot be ignored. The recommendation of the director, which is the basis or foundation for the order, should be read along with the order for the purpose of determining its true character, Milo. Entire record has to be read. If on reading the two together, the court reaches the conclusion that the alleged act of misconduct was the cause of the order and that, but for that incident, it would not have been passed, then it is inevitable that the order of discharge should fall on the ground as the appellant has not been afforded a reasonable opportunity to defend himself as provided under Article 311(2) of the Constitution. Now, para 15, my lord. A narration of the facts of the case leaves no doubt that the alleged act of misconduct on June so-and-so was the real foundation of the action taken against the appellant, and that the other instances stated in the course of the counter affidavit are mere allegations which are put forward only for the purposes of strengthening the defense, which is otherwise very weak. The case is one which attracted Article 311(2) of the Constitution, as the impugn order amounts to termination of service by way of punishment, and enquiry should have been held in accordance with said Constitution provision. That admittedly having not been done, the impugn order is liable to be struck down. We accordingly set aside the judgment of the High Court and impugn order at so-and-so, discharging the appellant from service. The appellant should now be reinstated in service with same rank and seniority he was entitled to before impugn order was passed, as if he had not been passed at all. He is also entitled to all consequential benefits, including appropriate year of allotment and arrears of salary and allowances up to the date of reinstatement. This appeal is accordingly allowed.
Yes.
I'm just taking to test. Note another matter that is relied on by my learned friend at the motion stage, 2013 3 SCC 607, State Bank of India and others versus Palak Modi. In fact, this this helps our case because it contains all the judgments rendered by the Honorable Apex Court in this issue regarding termination during probation period. Since the date of since the judgment of P.L. Dhingra, that is para 14 onwards.
You're reiterating, you're relying on the judgments for that proposition.
And yes,
311(2) is also available to a provisioner,
yes,
depending on the facts and circumstances.
yes, my lord. That is my basic case, my lord. I'm not troubling your lordships by reading same thing again and again, my lord.
Hmm.
Because para 15 onwards of this Palak Modi judgment, my lord, entire law has been discussed and, my lord, deliberated and conclusion was derived. So that will,
Yes.
so that will assist your lordships in coming to conclusion. That will assist your lordships to come to a just conclusion, my lord.
Yes. Other judgments you had placed before this court, Ratnesh Kumar and
Yes, Ratnesh Kumar, my lord, I have,
are all also on the same issues.
yes, also on the same issue. Ratnesh Kumar, para 27, if your lordships kindly take up.
Yes.
In the case at hand, it is clear as crystal that on the basis of a complaint made by a member of Legislative Assembly, an inquiry was directed to be held. It has been innocuously stated that the complaint was relating to an illegal selection on the ground that the appellant did not possess the requisite qualification and was appointed to the post of chest therapist. The report that was submitted by the Cabinet Vigilance Department eloquently states about the conduct and character of the appellant. The stand taken in the counter affidavit indicates about the behavior of the applicant. It is also noticeable that the authorities, after issuing the notice to show cause and obtaining a reply from the delinquent employee, did not supply the document. Be that as it may, no regular inquiry was held, and he was visited with punishment of dismissal. It is well settled law that if an ex parte inquiry is held behind the back of the delinquent employee, and there are stigmatic remarks that would constitute foundation, not the motive. Therefore, when the inquiry commenced and thereafter without framing of charges or without holding an inquiry, the delinquent employee was dismissed, definitely there is clear violation of principles of natural justice. It cannot be equated with the situation of dropping of the disciplinary proceeding and passing an order of termination simpliciter. In that event, it would have been motive and could not have been traveled to the realm of the foundation. We may hasten to add that had the appellant would have been visited with minor punishment, the matter possibly would have been totally different. That is not the case. It is also not the case that he was terminated solely on the ground of earlier punishment. In the fact, he continued in service thereafter. As the report would reflect that there are many an allegation subsequent to imposition of punishment relating to the conduct, misbehavior, and disobedience. The Vigilance Department, in fact, had conducted an inquiry behind the back of the appellant. The stigma that has been cast in view of the report received by the Central Vigilance Commission, which was ex parte, and when that was put to the delinquent employee, holding of a regular inquiry was imperative. It was not an inquiry only to find out that he did not possess the requisite qualification. Had that been so, the matter would have been altogether different. The allegations in report of the Vigilance Department pertain to his misbehavior, conduct, and his dealing with officers, and same are also gets accentuated by the stand taken in the counter affidavit. Thus, by no stretch of imagination can it be accepted that it is a termination simpliciter. The division bench has expressed the view that no departmental inquiry was required to be held, as it was only an inquiry to find out the necessary qualification for the post of chest therapist. Had the factual score been so, the said analysis would have been treated as correct. But unfortunately, the exposition of factual matrix is absolutely indifferent. Under such circumstances, it is extremely difficult to concur with the view expressed by the division bench. So in my humble submission, that yes, if you would have made some exercise, the VC, that while discharging in his official duty, he was he was not up to the mark as is required for the post of registrar, then fine. But in the backdrop of allegations of misconduct, here in this matter,
But it is this misconduct on the basis of which he has arrived that you are not suitable for a registrar.
Yes, my lord. Look, two things are there, my lord. Either you hold the inquiry.
Not misconduct. In view of these instances which are alleged, your behavior as a
Financial irregularity, my lord.
not only financial.
Yes.
There are other irregularities.
My behavior, my lord, what is this? Had it been only on account of my behavior, I would have understood. Had the VC recorded that, yes, he could
No,
not,
but how
he could
how,
not complete his work.
no, but how does a court find out that which of the conditions are more suitable or more
No, that is
relatable?
not the duty of the court.
Exactly.
Once,
So therefore, once there is a finding by the VC, whether an inquiry was necessary, whether confrontation, you are required to be confronted is one aspect of the matter. But you also agree, perhaps, that in the provision, ultimately your suitability has to be assessed.
my lord, there is no doubt about it, my lord.
Correct.
My suitability has to be
And
assessed.
the statutes and the rules don't provide.
Had there been, my lord, the instances wherein I was found unsuitable, had there been like I failed to complete my work in time, I keep my papers pending, I don't obey the order of the VC, those, my lord, there were, my lord, if
There
there are
can-
1 to
There
10,
cannot be a definitive list.
I understand, my lord. If there are 1 to 10, which contains, my lord, observations like those, absolutely fine. But out of that 1 to 10, if you have allegations like financial irregularity, my lord, insubordination, my lord, my lord, another one I just forgot.
Those are subjective, Mr.
Yes.
Das.
So if
Either you say that notwithstanding anything, probationer is entitled to 311.
True.
Therefore, whatever misconduct or other or suitability, that also, if it is punitive,
that is
you
one.
apply the protection,
Yes.
or you're available to the protection.
Yes.
Or is it a case that no, only in certain cases of financial irregularities you are entitled to a punitive, you are entitled to the protection because it is punitive or in nature? Or is it a case, let us rephrase the question,
Well,
do you disagree with the powers of the VC or the EC that your suitability is the whole reason required, is suitability to be assessed is the whole purpose for which you are kept under probation for 1 year?
you know, there is no dispute with because
Correct.
laws.
How is the suitability to be assessed?
Well, first of all, the suitability has to be assessed after
And
1 year. You have
whose subjective satisfaction are we to arrive at?
look, if we go by the law laid down by the Honorable Supreme Court in the first judgment that I read to your before your lordship, any administrative decision has to be objective. Honorable Apex Court said, if you are deriving a conclusion that the person is not suitable for the post, or if he is lacking on A, B, C, D, then you have to give him opportunity. It may not be in terms of a show cause notice. It may be an internal communication given to him that, look, Mr. So-and-so, Mr. Das, you are lacking in A, B, C. It is your provision. You improve upon all these things.
So
That is one aspect of the matter.
essentially your submission is no matter what, some form of opportunity ought to have been given.
Yes, my lord. That is my sum and substance, my lord. You cannot get rid of an employee in this manner, my lord. That too,
Only because you have the power to assess
yes, my lord.
suitability.
Your decision has to be objective, and the statute clearly says that that is another limbo of argument, my lord, that you can use this discretion after 1 year. Within 4 months, what we will get? Within 4 months of service, entire thing has been changed, and he is
No,
preponed to it.
that is a subjective satisfaction.
That cannot
How can you, on what basis can you say that within 4 months you cannot decide whether the person is suitable
because
or not?
provision says shall. I am not saying, my lord.
Okay.
It shall. It says shall. The VC shall.
Yes.
So that is my humble submission, my lord. I have given some saying only the relevant paragraphs, my lord. That your lordship's para 62, 63 and 80
Hmm.
and 160.
Hmm.
This is with regard to motive and foundation, my lord. Only 2 pages of paper. I have given only relevant paragraphs
Yes.
because the original judgment is, my lord, quite
Voluminous.
voluminous, my lord. This facility is there, that's why, my lord.
This is perhaps one of the foundations of the Indian judiciary in terms of a judgment.
Yes, my lord. This is the start of the entire change of law.
Yes.
62, 63, 80, and 160. The position of a probationer was considered by this court in so and so. Speaking for the court,
Yes.
Lordship will go through it, my lord. I'll
We'll
not
go
trouble-
through it, we'll-
Yes, my lord, because
Yes.
this is already. And lastly, my lord, this 89 3 SCC 311.
Yes. Give us the paragraphs.
I'm sorry, my lord. Name of the party is Dr. Mrs. Sumati P. Shere versus Union of India and others.
No, we want the
Seven,
paragraphs.
para 7, my lord. It's a small judgment, my lord. Only 4 lines. I'm relying. There cannot be any dispute about this proposition, that the proposition of law laid down in para 6, that the probationer can be terminated on the ground of unsuitability. We are not laying down the rule that there should be a regular inquiry in this case. In the given facts of the case, it has been said. All that wish to state is that if she is to be discontinued, it is proper and necessary that she should be told in advance that her work and performance are not up to the mark. So you are required to give this opportunity. That leads to the objectivity here in your recommendation, followed by the decision of the EC. So this
Okay.
is precisely my submission, my lord. I will reserve my right to give a short reply if required.
All right.
And in my humble submission, this impugn order is absolutely punitive. The allegations of financial irregularity, integrity doubtful are the foundations in coming to the conclusion of this impugn order, and it's required to be set aside. Not only one aspect,
Find us.
I'd like, Milord, I am on a lien of 2 years from Guwahati University, Milord.
Sorry,
I am on a lien of 2 years of
when
from
does
Guwahati.
it expire? It's already
It is,
expired.
no, Milord. It will be expiring on 5/5/2024, this year itself. So, in between, I am hanging, Milord, from the date of dismissal of this order because of the situation herein. So, Lordship, in my humble submission, Milord, this writ petition deserves to be allowed by setting aside and quashing the impugn order.
The main order will have to be defended by our respected senior, Mr. K.N. Chaudhary. He is appearing for the university. I am appearing for the respondent number 8, the Vice Chancellor, who has been made a party by name. So I will broadly, point out. One of the first things your lordship will notice in this case is there is a sufficiently bulky writ petition file, affidavits, additional affidavits narrating the entire Ramayana. But your lordship will not find the description of Lord Ram in any of the pleadings by them, which is the order of appointment. That order has been conveniently withheld, which we have annexed to our affidavit, my lord. If your lordship will
Perhaps-
first come to the affidavit.
Perhaps the petitioner wants you to go out of Guwahati to find that answer.
Your lordship will, your lordship will
He
come,
may not be available here.
your lordship will come to the order of appointment,
Uh,
which is at page 104, turning page 104. One of the conditions
Where are the paragraphs? Let us see the paragraphs where malice has been alleged to you.
But those, my lord, are, I think my learned friend is not even urging them. Because no submissions have been advanced. If necessary, I can address on that also, but since my learned
No
friend is.
malice. You are not alleging malice against the.
My lord, I have
Wonder.
alleged malage, when I filed the writ petition, I have.
Not now, not anymore.
After we file the affidavit.
My lord, I don't require in fact the allegation of malafide. Because their record speaks volumes, my lord.
Your lordship may kindly record this, they are not urging. And now your lordship will kindly come to the order of appointment. Each of the allegations of malafide that were made, we have not only rebutted, we have produced all the materials annexed to our affidavits to show that none of those allegations of malafide can even be remotely be sustained.
But he's not even urging it now.
Not even urging it, naturally.
Then-
So your lordship
We
will
keep this reserved for a moment, since my senior, Mr. Ken Chaudhary, he argues on merit, my lord. Reserved for me.
No,
Lordship-
why is the question of reserve? Reserve is
What
for
I'm
the,
saying,
reserve is for your reply.
reply. my lord.
First, you have to make your arguments. Either you decide to argue on malice or you don't. You have urged in your pleadings,
Yes.
but you have not submitted. Maybe it is not necessary. We don't know. It's for you.
Because what
But to say that this will be argued only on the reply,
Legal, yes, my lord.
because he has to know what arguments you have to make.
Exactly.
True, my lord, that is true.
All right. Will it be better to hear the
Mr. Chaudhary.
university first, or
I can address her, point out broadly, my lord. And main arguments have to come from the university defending the order.
who's
And
who's represent?
I'm told Mr. Ken Chaudhary is on legs. The lordship can have it sometime next week in that case for Mr. Ken Chaudhary's.
Records perhaps may be necessary, available. After we hear him, then we will hear you because your the primary allegation against the respondent it is malice,
That is not ours.
and malice has to be properly urged.
In that case, your lordship will hear Mr. Ken Chaudhary on a convenient date. And next. আজি পরবেলা উঠে যাবো, vice president.
Next. 20. 20, I think we have fixed some series. Second would be it. We'll keep it on 20. Let us see. As a part heard matter. Matter heard at some length. Counsel for the petitioner reserves his argument for a reply after the arguments of the respondents. Matter be listed again on 2002-24 for arguments to be advanced on behalf of the university as well as the other respondents. Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr. Vishwakarma, appears for respondent 8. And Mr. J. Patwari appears for the university and is led by Mr. K. N. Chaudhary, Senior Counsel. Records of the university, if may be kept ready for perusal of the court if required.
The lordship will keep it as part heard. Otherwise,
Yes,
again,
yes.
part.
Deeply.
So let's show it as a
Lordship, may I please, Lordship, kindly see the last order, Lordship.
just 1 minute. Yes.
My lord, so far as the payment of my lord that area amount to the erstwhile my lord, female attendants. Now, my lord, the authorities have identified this my lord 1016 numbers of petitioners who are pursuing before this honorable court in the contempt petition, including the associations. And my lord, shortly it will be released. Because my lord, to verify everyone in the entire state, it will take time. So my lord, they have decided that my lord, so far as this contempt petitioners are concerned, they should be given a priority. Sometime because of the budget session and all, my lord, assembly is going on. It is lying in the desk of the department minister. Moment it is my lord approved,
When is the
it will be less than my lord 62 crores now, my lord. At least initially that can be released. Because by this time, my lord, many my lords, persons have already expired. And my lord, in 1980s, they were engaged. At that time, there was no bank account and all, my lord, to verify.
have you seen this?
I've
I've
given
seen
you,
also, my lord. Earlier also, there were, my lord, several, my lord, times, lordship.
No, now it
Budget
has been, my lord.
Budget was created, lordship.
No, they have taken a decision.
Yeah.
My lord, yes, lordship. I'm submitting before this one, so for your lordship kind information, lordship. Earlier, there were many times budget was there, lordship, and those budgets were, my lord, left because of, my lord, overlapping budget, lordship. In this, the petitions are, my lord, apprehended, my lord, in this time also, my lord, something maybe happened, lordship.
We'll see because you are filing a contempt.
Yeah.
Mr. M.H. Ahmed appears for the petitioners and submits that the orders of the writ courts as per judgment and order dated 13/10/2017 passed in WPC 900/2013 has not yet been complied with. As per the last order 10/1/2024, this court directed the orders to be complied with, failing which the proceedings under Contempt of Courts Act 1971 may be initiated. So, Mr. B. Gogoi, Learned Standing Counsel Finance, places before the court copy of the instructions issued by the Department of Health and Family Welfare, wherein it is stated that payment of that a decision has been taken for payment of the 1016 petitioners who has moved this court, amounting to a total of rupees 62,6744,068. This entire amount is for these petitioners.
Yes, my lord. So far as this freeze is concerned.
Stop. Mr. Gogoi, however, submits that because of the budget session presently going on in the state, this order, the necessary orders have not been, could not be passed. He submits that the same will be issued.
My lord, let it be on 15th of March. Prior to 31st March, 15th of March, I will come up with something my lord. On 15th March.
We can record, but if you don't, then we will be compelled to issue proceedings under draft proceedings, because you see, this is out and out a violation of the directions. No order, no extension, no application for extension has been filed.
That part my above, my lord, about it is another.
No, you are not aware, but we are apprising you.
Lordship,
We are bringing it to your notice.
my lord.
When there is a direction to comply, you have to comply.
Yes, no point, my lord.
So therefore, 15th of March will be too long a time for us to find out whether the order has been complied.
First of March or 29 or 28, by 28, the budget session will be over. On 1st of March, something might come up with, let me.
All right, matter be listed again on 1st of March, as it is submitted that the budget session will be over on 28th of February. List on 1st of March.
Obliged.
You're appearing?
Yes, my lord. For respondent number 2 in item 52.
Mr. A. Das appears for respondent number 2 in item 52.
Contempt case number 452 of 23.
In contempt case 452, you're for the respondent.
Number 2.
Number 2. All right.
Obliged, my lord.
Some correction.
My lord, some correction, my lord.
Who's for the respondent?
The BTC and the state government, my lord.
You have to call
I'm
for the
for-
BTC.
I am for the Elementary Education Department. So then lordship, the correction which has been sought for, perhaps it will be the Secretary, Department of Education, BTC.
It should be a secretary, government of
Because
education,
because matter pertains to BTC
BTC.
and they have a secretary.
Hmm?
Secretary, Department of School Education, BTC is there.
But the promotional aspect, my lord, the entire Assam, my lord, it is, my lord, decided by the government of Assam Education Department, secretary,
Only. Promotion.
BTC, party and entity to economic.
In para 5, you want what change?
My lord, instead of that last 4 lines, my lord, 5 lines.
Hmm.
uh,
Director BTC.
Director of Education BTC, it should be, my lord, the Secretary of Education, Government of Assam, my lord. He is the, my lord, respondent number 4, Department of School Education. He is the proper and appropriate authority, my lord, as regards promotional matter. Paragraph number 9, my lord, page 11.
Yes, who is the authority for promotion? Mr. Sharma? In the BTC area, where is the BTC council? Call him.
BTC.
Is it the secretary or the education? I mean, is there a principal secretary there?
Lordship, there is secretary. Secretary,
secretary.
Principal Secretary, Department of School Education is there.
In BTC.
BTC, Lordship.
And that is the appropriate authority.
My
No,
lord, it
my
will
lord,
be the
regarding
appointing authority. Here, my lord, the petitioner's appointments who have made them, my lord, that will be.
made by the Education Department, Government of Assam, my lord.
Then, my lord, it will be the state. Lordship.
Okay. I heard learned counsel for the parties. This IA has been filed, praying for a modification of the order dated 4/8/2023, passed in WPC so and so. Stop. Learned counsel for the applicant, writ petitioner submits that in the order dated so and so, the writ petition was disposed of. The petitioner had two prayers in view of the enhancement of age from 60 to 60 years by the appropriate authority in the Education Department, Government of Assam. His prayer was not required to be considered. Stop. However, in respect of the other prayer, seeking promotion, this court directed dispose of the writ petition with the following direction, para 5. Para. It is submitted by the learned counsel for the petitioner that in the said paragraph, the petitioner was directed to file his representation before Director of Education BTC, and the director, and thereafter said authority will look into the matter and pass a reasoned order. Stop. The submission of the learned counsel for the applicant is that in matters of promotion, it is the secretary of the department who is the appropriate authority. And therefore, instead of Director BTC, the representation is required to be filed before the secretary, what is it called? Secretary of
Secretary to the Government of Assam, my lord. Paragraph 4, respondent 4, my lord. Department of.
Government of, yes, Department of School Education.
Secretary to the Department of School Education, Dispur. Stop. It is this authority, it is respondent 4, it is opposite party 4 in the said IA, as the said authority was the appointing authority of the writ petitioner. Stop. The limited prayer in the IA is for modification of the order to the extent of
Director of Education, BTC.
modifying the words Director of Education BTC appearing in para 5 of the said order to, within quotes, Secretary to the Government of Assam, Department of School Education, Dispur. Stop. Para. Learned counsels appearing for the Education Department, Mr. P.N. Sharma, and Finance, Mr. B. Gogoi, does not object to the prayers made. None represents the BTC. Or who appears for the BTC? Mr. P. Nayak appears for the BTC. Since no objections are raised by the respective standing councils, this court is of the view that the limited prayer made in this IA can be allowed. Accordingly, the petitioner will file necessary representation before the Secretary to the Government of Assam, Department of School Education, Dispur, Guwahati, and the said authority within a period of 2 weeks thereafter dispose of the representation and pass a speaking order, and a copy whereof will be served on the petitioner. Stop.
It's regarding.
Accordingly, the
promotional.
petitioner is now permitted to file his representation. Have you filed already?
My lord, I have already filed before the BTC, my lord.
He is now permitted to file a fresh representation before the Secretary so-and-so within a period of 3 weeks
My lord.
from the date of receipt of a certified copy of this order passed in the IA, and the entire exercise be completed within a period of 30 days from the date of receipt of the representation by the Secretary to the respondent number 4, Secretary to the Government of Assam, Department of School Education. Whereas this order shall the order dated 4/8/2023 passed in WPC so and so is modified to the extent indicated above. Stop. This order shall be read together with the order dated 4/8/2023 passed in WPC so and so. IA accordingly stands allowed and disposed of.
Most of them.
Your lordship has heard this matter, your lordship, and fixed for delivery of order.
Today,
Written submission.
Oh, or if your lordship so desire, we can file a written note of our.
yes, better
Yes, better.
file a written note. You should file a written note
That's
once the matter is heard. But it should be
No, I'll be very
precise.
precise.
Judgments we have already placed, your lord.
Shed in charge.
Lordship said in.
Shed in charge. Okay. Parties are permitted, learned counsels appearing for the parties are permitted to file a short synopsis of the written arguments made within
Let me,
1 week,
lords, 1 week.
1 week from today. Matter be listed again on 27th,
Deep rule.
22nd of February.
No, I am for the respondent, ONGC.
No, none for the petitioner. What is the issue about? What is the matter? What is the
Actually,
matter?
I am without brief, my lord. Actually, nowadays, there is no indication in the part two list also, my lord, sorry, part one also, that part two matters will be taken up after part one matter.
It
There
is
a pro-
there.
Eh?
It is there in the list. Have a look.
I have seen that.
No, you see the list.
Okay.
It's already reflected.
We thought, my lord, nowadays, since matters are listed from that list as the top of the list, that is why. ঠিক আছে, আপনি দিতে হবে।
It's listed.
Oh. Anyway, my lord, I am without brief.
Okay, none appears. Passed over. None appears for the petitioner, Mr. S.K. Chakraborty for the
Respondent ONGC.
respondent ONGC. Matter be called up again later in the week. We called up again on the next available date. Yes. Any other? No other matters.